Hey, Jim Hart back at you here from the Hart Law Firm. Today I want to talk to you about the 5 limits to divorce mediation. So I've talked a lot about divorce mediation in the past. I talked to a lot of my clients about divorce mediation. Before we get to that, let's head over to the little disclaimer, shall we? Alright, so I've talked to people about the limits of divorce mediation quite a bit. I talk to my clients when they come in to see me repeatedly. Divorce mediation is a wonderful way to resolve your case quickly, especially in North Carolina, but it's not foolproof. There are some limits, and today I want to talk to you about 5 of them. So the first limit to divorce mediation is that nobody can force you to mediate your case. And what that means is that not only can nobody force you to mediate your case, nobody can force your spouse to mediate your case. So I actually had a conversation with a client yesterday who wants to move the process along a little bit faster, but they had scheduled a mediation and his spouse did not show up, or she rescheduled at the last minute or something like that. And he was frustrated because he really wants to mediate the case, but he can't. This happens a lot. I can't tell you how many times this has happened with my clients, where they come in and we're ready to mediate the case, and for some reason either my client decides they want to back out at the last minute or the other side decides they want to back out at the last minute. That happens quite a bit. It is a big problem. It doesn't happen all the time, but just be aware that nobody can force you to mediate the case. Now, can a judge tell you if you're in court about to have a hearing, go in the other room and mediate this case and don't come back until I know that you've made a good faith attempt to mediate your case? Yes, a judge can't do that. So this is kind of a little bit of a misnomer. Nobody can force you to mediate the case, but you can be court ordered to mediate your case. Now, once you get there, what you do and how well you decide to proceed in that process, the amount of good faith you put into proceeding in that process, that's up to you. That's up to your spouse. Nobody can force you to sit down and try and resolve your case. But they can force you to go to mediation. So that's what you need to know about that. So that's limitation number 1. Limitation number 2. Once you get to mediation, it kind of goes in line with limitation number 1. The mediator cannot force you to resolve your case. So I've sat in mediations with clients where we've been in mediations for pretty much an entire day, 8-10 hours, and you get to the end and there's one little technicality. For some reason, either my client or the other client, they don't want to resolve the case because of that one little issue, and so they don't resolve the case. Nobody can force you to resolve anything if you go to mediation. The mediator can't force you, your lawyer can't force you, the other lawyer can't force you. Nobody can force you to do anything that you don't want to do at mediation. That's one of the great things about mediation, but that's also one of the big downsides of mediation, because if you're trying to drag out a case or your spouse is trying to drag out your case and not get it resolved, they can go to mediation, waste a lot of time and money and energy and effort and everything else, and then just walk away at the last minute. They put forth the good faith effort, they've tried to mediate the case, and they've decided, you know what, this isn't going to work, and then they walk away from a deal. That can happen. Third limitation to mediation: the mediator cannot give you legal advice. So a lot of people will try and go to a mediation. They'll hire a private mediator to help them and their spouse mediate their case. All well and good. That's great. And in some cases, that is a wonderful way to do it, but it's not always the best way to do it, especially if you have a really complicated case. And the reason for that is most people don't understand, but in a family law case, there are a lot of really complicated issues. You can't even fathom how many complicated issues are that you might need to resolve. And how you decide to do one thing may impact the way something else is going to, the dominoes may fall on something completely different. Whether or not you decide to keep the house or your spouse is going to keep the house may impact how much money is going to come out of or go into your retirement account. So there's a lot of different issues and moving parts in a family law case. The amount of assets you get may affect the amount of alimony you get, and vice versa, or pay. So you need to understand that if you go to mediation without a lawyer by your side and there is a mediator there, the mediator cannot give you legal advice and tell you whether the deal that you're coming up with is a good deal or bad deal or anything else. They can't give you that legal advice. Only a lawyer can do that, so you need to be aware of that if you go into a mediation and you're unrepresented. Now, most mediators who are represented, who are court appointed, and which means that a lawyer is going to be going to that mediator in most cases, they won't conduct the mediation if both spouses are not represented by a lawyer. So there is that. But some will. I presume there's probably some out there that will. And so that's what you need to know. That's limitation number 3. The mediator is not going to give you legal advice. And similarly, along with that is limitation number 4, and that's that the mediator is not going to draft up your separation agreement for you. So even if you go to a mediator with you and your spouse and you have a mediator and you get everything resolved, you're still going to need to go to a lawyer to draft up a separation agreement, or you're going to need to do that on your own. We don't typically recommend that you draft a separation agreement on your own. As I just mentioned, if you just rewind about a minute or two, there's a lot of really complicated issues that go on in a family law case, and I don't recommend. It's a bad move to try and draft your own separation agreement without a lawyer. They can get really complicated and really confusing, and I've seen a lot of people come to me after the fact who have drafted one on their own, and it just leaves lots and lots of problems. So don't try to do that. And a mediator can't do that for you. And in some cases, they won't draft anything at all. They'll just ask the parties to draft up what their agreement is and sign it. So that's something you need to be aware of. That's limitation number 4. Limitation number 5, I think, is probably, this is probably the biggest limitation in terms that differentiates a mediation from court. It's a big benefit in some cases, but it also is a huge drawback in others, and that's that they're not all successful. There's a lot of mediations that don't resolve. Now, I would say in my experience with my practice, roughly 80 to 90% of cases that we take to mediation, we are going to get resolved, but that is not always the case, and you could be in that 10 to 20% of cases where the case does not resolve. So that is a downside, is that there's no guarantee that anything's going to happen. You might spend a lot of time, a lot of money, pay a mediator, pay a lawyer, all these things, and you're not guaranteed to have an optimal outcome or even an outcome that you like. So you might reach a resolution, you might not be happy with that resolution. In fact, a lot of great mediated agreements, both parties hate, and the reason they hate is because they both had to give up something to get to that agreement. And if they hadn't given those things up, they'd still be fighting in court. Now that's the other side. In court, you're guaranteed to have a resolution. One way or another, at some point, you're going to have a resolution because the judge is going to tell you what is going to happen. You may not like what the judge says, and there's a lot of reasons why I don't necessarily recommend my clients take cases to court, but you're going to get a resolution. That's it. The 5 limits to divorce mediation. Let's go through those one more time. First, nobody can force you to mediate your case. A judge can, but you don't have to show up and do anything. Number 2, once you get to mediation, the mediator is not going to help you or force you to resolve your case. Number 3, the mediator can't give you legal advice. Number 4, the mediator cannot draft up a separation agreement for you. And number 5, there is no guarantee that you're going to be successful with your mediation. So if you have any questions, please feel free to reach out to me. My name is Jim Hart. I am the principal attorney here at the Hart Law Firm in Cary, North Carolina. Our number is 919-460-5422. If you have other questions, you can either give us a call to schedule an initial assessment, or feel free to reach out to us on our website. It's right down here, jameshartlaw.com/contact, and you can go ahead and schedule an assessment right there on that webpage, or you can reach out to us, email us, and we will call you back. Lots of tools and resources on the website. Also, don't forget to hit the little subscribe button down here. Give us a big thumbs up and comment below if you have any questions. I can't give legal advice in YouTube comments, but we can steer you in the right direction. Steer you in the right direction if possible. That's it for today. Have a great day, folks, and we'll be back next week with more about mediation. I'm going to kind of make this into a little series, and we're going to have 4, 5, 6 videos all about mediation. So we'll be back next week with another great video. Thank you. Have a good one. Bye-bye.